You co-own the property with your kids to avoid the probate process, they will lose the step up in basis on their half of the property. So let's say you purchase a property for $100,000 and you give them half of that property. So now you both are 50% owners and the value of each of your halves is now $50,000. And so you pass away many years later and it's worth $400,000, making each of your halves worth $200,000. So they get a step up in basis on your half. So the $50,000, it gets stepped up to $200,000. But on their half, it does not get a step up in basis. They have the original cost basis. And so when they go sell that property, they will owe capital gains tax on the difference between what their half is worth minus what the cost basis of their half is. So it's $200,000, which is what their half is worth, minus the $50,000, which was what their half was worth when the property was purchased. And so that's a $150,000 difference. They will owe capital gains tax on that. So when you're setting up co-ownership to avoid the probate process, you want to make sure you're weighing the financial risk versus reward, because you're going to pay a lot more on the back end for capital gains tax compared to how much you would pay for a probate attorney. And so another way you can do this and avoid all of this is you can put your house inside of a revocable trust. You will maintain full control over the property inside the trust if you're the trustee, and then the trust owns that property. When you pass away, it avoids the probate courts altogether. They won't have to hire a probate attorney, and then they can be the trustee and distribute that property out to themselves. And so they will still get the step up in basis, and they will also avoid the probate process. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.